May it please the Honourable Court, I am Muhammad Khazali acting as defence counsel for the offender in this case. Our side would like to ask for court in favour to reduce and evaluate the punishment for the offender on the following grounds. Your Honour, the first ground that I would like to state was in regards whether the offender shall be given lesser punishment or not. Your Honour, defence pray to the court to lessen the punishment as the accused has pleaded for guilty. Defence will come up with two factors in plea of mitigation for the punishment to be lessened. First factor will be due to the fact that the offender has pleaded for guilty. Referring to section 176 subsection 2 clause R of the Criminal Procedure Code as follows, the particulars to be incorporated in the record shall include the court notes on previous convictions, evidence of character, and plea in mitigation, if any. In this case, the court shall consider to lessen the punishment for the offender as the offender has pleaded for guilty on the offence charge, and the plea of mitigation as stated in the section can be used as the factor to reduce the sentence. This can be referred in the case of PP versus Shariton anak lelaki Pacamutu, where the accused was sentenced to 6 years imprisonment after a 1/3 reduction for having pleaded guilty and cooperated with the police. Also, in this case, the court should take a look on the record of the offender, as the offender only committed this particular offence once in his lifetime. Thus, the punishment can be considered heavy for the first-time offender like the accused. This can be referred in the case of Abdul Karim versus Regina, where the court substituted a sentence of 3 months imprisonment with a fine of Rm400 as the accused was a first-time offender. Second factor that can be considered in the plea of mitigation is the effect of the conviction toward his family and his job. For the effect on family offender, the accused in this case is the eldest son, and he is the sole breadwinner of the family since his dad passed away in 2010. He has to look after his 3 sisters and a brother. Therefore, I humbly ask for the court to reduce the sentence as the offender is the only person who working and has his family to be supported. And if the sentence could not be reduced, thus it will put the family in financial distress. This can be referred in the case of Chan Sit Home versus Public Prosecutor, where the accused, whom is a first offender, has a sizable family to support, pleaded guilty to possession of raw opium, but was sentenced to 1 year imprisonment. On appeal, the judge held the imprisonment was excessively severe and replaced it with a fine of Rm2,000. For the effect on part of the offender job, the accused in this case was offered as a manager at Tesco beginning on 2nd of May 2020. However, on 5th of April 2020, he was arrested and charged with the offence. Therefore, as stated in the offence, he will be put in imprisonment for a term not exceeding 6 months, where during that period is the time for him to start working at his new workplace. Therefore, on our part, defence plead for the court to lessen the punishment and not sentence the accused in imprisonment. This can be referred in the case of Winston Rajah versus Public Prosecutor, where the appellant in this case was a first offender and he was undertaking a course in computer studies. Thus, an immediate custodial sentence of 12 months was not appropriate at the moment and excessive in the circumstances. Therefore, one of the options which available for reducing the punishment for the offender can be seen in section 283 subsection 1 clause B of the Criminal Procedure Code. In every case of an offence in which the offender is sentenced to pay a fine, the court passing the sentence may, in its discretion, allow time for the payment of the fine and direct payment of the fine to be made by installment. Therefore, defense humbly requested for the court to grant permission for reducing the punishment, as the court may give longer time for the offender to pay the fine and for the payment to be made in terms of installment. Your Honor, for the second ground, I would like to state that was in regards whether the offender can be waived from the punishment or not. Your Honor, defense pray to the court to waive the punishment as for the following reason. First reason will be on virtue of pardons and commutations. Referring to Article 42 of Federal Constitution as follows, the Yang di-Pertuan Agong and the ruler of Yang di-Pertuan Negeri of a state has power to grant pardons, reprieves, and respites in respect of all offence which have been tried and all offence committed in the Federal Territories of Kuala Lumpur, Labuan, and Putrajaya. Defense believe that court can consider for the punishment to be waived if the pardons and commutations has been attained from the YDPA or from the ruler of the state. Thus, the record of the conviction will be uplifted from the proceeding. Second reason would be by virtue of good behaviour bond. Referring to section 173A subsection 2 of Criminal Procedure Code as follows, when any person is charged before the court with an offence punishable by such court, court may, without proceeding to record a conviction, make an order discharge the offender conditionally on his entering into a bond with or without sureties to be of good behaviours. Defense referring to the case of Ramli Hussein versus Public Prosecutor, where High Court set aside the sentence of imprisonment on the appellant who has convicted in offence under section 156 of Penal Code, and good behaviour bond has been ordered for the term of 3 years. Therefore, the defense believes that as the offender is the first offender for the offence, and taking account the fact that the offender has responsibility towards the family, thus defense humbly requested for the court to consider the reason as stated above from our sides to waive the punishment towards the offender. Your Honor, that is all from the Defense Counsel. Thank you.